topical ones, definitely. So, what are we talking about today? Essentially, this session is an update of all of the interesting, in my view, interesting things that happened in the course of 2021 that I think contain important bits of information for you guys in managing your projects in 2022 and going forward as well. Loads to get through today because it was a very, very exciting year with lots of interesting cases. At the end, we are also going to do a looking forward or coming soon section. And again, looking at things that might change within the course of 2022. So, the first few slides in the pack are, as normal, marketing information from the company I work for, which is Driver Trett. As you know, I get very few opportunities to put pretty pictures on my slides just because of the nature of the topic I am involved in. So, we provide support to the engineering and construction industries, essentially from cradle to grave. So, quite often, I will get involved on an upfront side, looking at the contract conditions that have been proposed, going through those with a red pen, thinking about operational issues and what specific things that my subcontractor, main contractor needs to change, and then actually helping them negotiate through up to the point where the contract is formed. During the course of the contract, again, getting involved with odd issues that might come up in terms of assessment of compensation events or entitlements, or do they have an obligation in relation to a particular area of design? And then, of course, towards the end, looking at the agreement and liability of the final account as well. So, as you can see, we work across many of the sectors that CECA themselves work in as well. We are a market leader in expert witness, planning, commercial, technical. Importantly, today for me is all about dispute avoidance. But when we don't manage to get a negotiated settlement, of course, we also get involved on the dispute resolution side. We were established in 1978, stock market listed with offices worldwide. In terms of the offices in the UK, we've got a lovely map there showing the location of all of these offices. I work out of our Hooton, Cheshire office. Head office is in Haslingden, and of course, we've got offices around the rest of the UK as well. In terms of the services we provide, they fall into three distinct categories. On the left hand side, you can see we've got driver project services, and essentially we can provide people onto live construction projects. So they could be project managers, quantity surveyors, or planners on a short, medium, or long term basis, depending on client need. I've already given you a bit of information about what I do at Driver Trett. As well as that, obviously, we have a team of planners and delay analysts who actually can look at your updating of your programs, monthly reports, and of course looking at claims for extensions of time, etc. The other area of the business, of course, within Driver Trett is the dispute resolution services section. And within Driver Trett, we do have mediators if that's something that you think would actually help resolve a particular issue. And of course, we act for parties in adjudication as well. On the right hand side, you can see Dialis, which is our expert witness division. And we have experts in quantum delay and technical to assist with any issues. Normally, they would be acting in proceedings in arbitration or litigation. And so, if you look at some court cases, you will see the Dialis name actually mentioned. I might inspire you to do some further reading after this session. We produce a twice a year publication called The Digest, and it has articles written not just by driver, Trett, and Dialis people, but also we do get people to guest articles as well that we think that they have got a particular area of expertise. I don't think I've seen an issue of The Digest without a NEC article in there. There's always plenty to talk about on that particular form of contract. A little bit about me. So I fall into that wonderful category of being a quantity surveyor. I have a degree in quantity surveying and I'm chartered. I used to work for a main contractor and I was there for about 5 years as a site QS, and that was Balfour Beatty. Went on and then completed a law degree and my solicitor's exams, and I've now been in construction claims consultancy for over 20 years. That's the end of the introduction. So let's have a look at some cases. And the intention was very much that I was going to concentrate on 2021 cases, but this case snuck in at the end of 2020. And actually, given all of the issues that are happening at the moment, particularly with price increases, I did think it was worth talking about this particular case. So, Altera and Premier Oil. And the question that was being asked in this case was, if a contract includes a written formula and a worked example as to how the formula works, which will a court uphold if they produce different results? Now, the background to this case involved Premier hiring an oil vessel from Altera, and everyone had agreed the daily rate to be paid. And the contract included a rate adjustment, and that was going to be applied annually depending on the availability in the previous year. So the contract contained this formula for adjusting the rate, but the complication came with the appendix. The appendix contained worked examples, and the worked examples included two additional steps which were not covered in the formula. And so we have the two parties diametrically opposed. We have Premier saying it's just the formula that applies and not the worked example, whereas Altera said, you're wrong. It's the worked example that takes precedence. The court decided in this particular case that it was indeed the worked example that applied. And this is despite the fact that the contract contained an order of precedence which confirmed that the contract that contained the formula took precedence over the appendix which contained the worked example. Secondly, the worked example also produced a result which was considered to be generally unreasonable, but the court decided this on the basis that the worked example in the appendix was seen as a more detailed interpretation and more reflective, essentially, of the parties' intentions. Now, I truly do believe that we are going to see more and more formulas appearing in contracts going forward. Earlier this week, I was giving a lecture on an NEC contract on a particular project. And sure enough, there was X1 glowing at me, which of course is the price adjustment for inflation within an NEC contract. Actually, the NEC version is fairly straightforward. I do think at tender stage, you should effectively, I'll call it wargaming, the actual formula and a few worked examples. Given this particular case, we do need to take great care about including worked examples in the contract. Altera massively benefited here, and Premier Oil were rather grumpy at the result. So, if you are going to put a worked example in there, check and double check the formula and the worked example to make sure they contain the same steps. And certainly also putting the formula and the worked example in the same place in the contract, in the same hierarchy, essentially. So that was my 2020 case because it just came in at the end of 2020. So 2021. Certainly a fairly important case in 2021 was the case of Balfour Beatty Regional and Vanel. Now, actually, it wasn't Balfour Beatty who entered into this particular contract. It was Mansell, but of course, Mansell had been bought out by Balfour Beatty and they'd had a name change. So, the parties in relation to this, we have the employer, Technip Umbilicals, which I've referred to as TU in the next few slides. The contractor being Mansell, who became Balfour Beatty Regional, and the piling subcontractor, who were called Vanel. And the works in dispute here were worth about 1.2 million. Very interesting story, but essentially it all revolves around liability for excessive settlement. Now, of course, when there was excessive settlement on the project, discussions were taking place between the employer and Balfour Beatty Regional, and Technip were not happy. But there was a deal done between Balfour Beatty and Technip that Balfour Beatty would remediate on a without prejudice basis. So, in other words, if it turned out that it wasn't Balfour's fault, then Technip would pay, but at least that got the job moving. Technip also, however, claimed business interruption losses, and quite often these business interruption losses are significantly more than the value of the actual remedial works themselves. So Balfour Beatty obviously then launched a claim against Vanel for remediation and other losses. So essentially, this claim is being bumped down the line. And Vanel were not happy. And they looked back at the chronology of events and the formation of the contract. 28th of May 2012, Vanel gave a quotation including its terms of business. Now, importantly, those terms of business include what I generally refer to as LOL clauses. Obviously, if you're texting regularly on WhatsApp, LOL tends to stand for laugh out loud, but not here. We are talking LOL clauses being limitation of liability clauses. And in particular, here, the, the term that Vanel wanted to rely on was a clause that says we limit our liability to repair and we have no liability for consequential losses. So Van El had done what I consider to be at tender stage a good job. They gave a quote, they referred to its terms, and the terms appeared to have good protective clauses in there. Got a little bit sticky then because it was clear that it was going to be Van El that were going to do the work. And Van El requested a letter of intent or an order. And on the 1st of June 2012, Balfour Beatty sent a letter of intent to Vanel. Now, those of you who have seen me speaking on letters of intent before, you know that I split myself in half when I'm talking about letters of intent. If I think about you as individual companies, the rules are really clear. Don't go down the lines of letters of intent. But if I think about the commercial realities of the firm I work for, letters of intent are a good thing for our business because we get lots of work out of them, which definitely means it's not good for your business. So avoiding letters of intent is something that both of these parties should have been doing. But anyway, back in 2012, the letter of intent was issued by Balfours to Vanel. And on the 11th of June, so 10 days later, Vanel accepted that letter of intent. And the piling works were then done between June 2012 and August 2013. Late in 2013, I think it was November time, they signed a subcontract and it was a JCT 2011 design and build subcontract. The issue then was all about the sub because there was other works being done on the site. Did the subcontract actually take into account all of the work that Vanel had done on the project? Or did it just take account of the work that was done after 2013? The court held that the signed subcontract applied retrospectively to all work, including the piling work that was done under the letter of intent. The subcontract itself didn't specifically refer to defective work, but the court decided that the subcontract did apply retrospectively, and they looked in particular at the parties' conduct. Both parties had used a single project number for all of the works, And the applications and valuations covered all of the works on an accumulating basis. Now, because the JCT 11 design and build subcontract applied, including those terms, effectively those terms meant that Vanel's quotation and its terms were superfluous and did not apply. And importantly, the limitation of liability clause that Vanel wanted to rely on was irrelevant. It didn't actually form part of the subcontract. So Vanel should have been able to say, look, we'll repair the works, but that's it. But here, Balfour Beatty were able to, as I said before, bump the claim down the line. So essentially, it was Vanel who was responsible for issues such as consequential losses, business interruption, losses, etc. The clear advice from this is to be very, very careful about the terms and conditions that apply, and in particular, limitation of liability clauses. They need to have specific review on every single contract or subcontract that you enter into. We go from piling to a residential development in London. And here the parties are Downs Road Developments and Laxman by Construction. Such an interesting case. And for me, it's interesting because, of course, it's back to that old payment regime and payment notices issue. The project was for the construction of 79 residential units in London. This was a JCT Design and Build 2011, and the project was worth 27 million. Now, in February 2020, Lambach Spy actually issued their application for payment for the sum of 1.9 million. Everything was in order, had the sum due, the basis on which the sum is calculated, everything was fine. But those cheeky so and so's at Downs Road Developments on the 3rd of March issued payment notice number 34 for £1. And not only did they issue it for £1, they actually took 3% retention off the pound. So the payment notice was for, would you believe this, 97 pence. Now, I'm going to call that a holding payment notice because Downs Road knew that LC were actually entitled to more money. But they just realised that they didn't have time within that magic 5 days to actually issue the proper documentation. So on the 9th of March 2021, payment notice 34A was issued. Now, it wasn't for 1.9 million, but it was significantly more than 97 pence. So payment notice 34A was issued in the sum of £657,000. Lambaxi Construction were very unhappy and they started, I'm going to say here, rather unusually, they started a true value adjudication for the outstanding 1.2 million. So roughly the 1.9 less the 657,000. And through the course of this true value adjudication, Downs Road Developments brought up a problem on the project, which was to do with the capping beam. Essentially, they said, look, we have got a counterclaim, a contra charge, and there's an issue with the capping beam, and we think that this issue is worth 150,000. The adjudicator looked at all the paperwork actually and didn't really find in favour of either party. The adjudicator decided that Laxman by Construction were only entitled to 104,000, significantly different than the 1.2 million pound. And the adjudicator also decided that the capping beam problem was quite simply not relevant. They ignored it, despite the fact that this was a true value adjudication. Downs Road refused to pay the 104,000 and said that the decision was unenforceable because of the adjudicator's failure to consider the capping beam issue. And of course, this particular case then goes to court. It was held in this case that the first payment notice that was issued for the £1 less 3% retention was invalid and ineffective because Downs Road Developments did not genuinely believe that £1 was due. Now, in my view, what Laxman Buy could have done and should have done is they should have issued a smash and grab adjudication on the basis that payment notice 34 was invalid. Because, of course, the later one came on the 9th of March, and so that was out of time. However, what the courts were faced with here was looking at the true value adjudication and whether this decision should be upheld or not. The court decided that the adjudicator had taken too narrow a view of its jurisdiction and the capping beam should be taken into account. The adjudicator's failure to consider this issue was a material breach of natural justice. Quite simply, the decision was unenforceable because the issue of the capping beam could not be severed from the rest of the decision. So, in my view, Downs Road Developments actually came off very well here, and I don't think it's particularly fair. They had played a game, in my view, in terms of the issue of the payment notice. Laxman Buy should have gone down the smash and grab route and then would have been paid the 1.9 million. They'd gone down the true value adjudication, and then actually the adjudicator themselves had messed up. So Laxman Buy Construction effectively didn't just end up with nothing, but of course they had to pay the adjudicator's fees and the court costs and the other side's court costs as well. The other thing to say here, holding payment notices quite simply, I would now say that they're not effective. When you're looking at a true value dispute, all possible defences must be considered. And as I said a minute ago, if Laxman Buy had proceeded on a smash and grab adjudication, they would have won because the developer had no genuine belief in the payment notice and there are no need to consider defences on a smash and grab. Now, someone has asked a great question about payment notice 34A and whether that could be treated as a pay less notice. My view, but obviously I haven't actually seen the notices that were issued. My view is that it couldn't be because it was actually badged up as a payment notice. If Downs Road had have badged it as a pay less notice instead, then it would have been effective. But because it was badged wrongly, that wasn't a possibility in terms of what Downs Road could rely on in this particular case. The badging in relation to payment notices and pay less notices is vital. This is one of the very rare cases where an adjudication has happened and it goes to court, and then the adjudicator's decision is not enforced. If I was guessing, less than 1% of adjudication decisions actually end up in court. And of those, less than 1% are not enforced. So this is a rare case indeed. And we'll move on to our next case. This attracted huge media attention in the construction law journals when it came out. Triple Point Technology and PTT. And it's all about liquidated damages. The contract here was dated the 8th of February 2013, and it was for the design, implementation, support, and maintenance of a software system. So it's not exactly a construction case, but actually the decision is directly transferable into construction cases. The works on this project were delayed and they were never completed. And there was a dispute regarding payment, which then resulted in the works being suspended and eventually terminated. There was a liquidated damages clause that confirmed that the employer was able to claim 0.1% of the contract sum for unfinished work per day until the work was accepted. Now, phase one was 149 days late, and phase two was late, and importantly, it was never finished. And this case is all about the imposition of liquidated damages, and in particular, liquidated damages after a contract has been terminated. And why this case attracted so much attention is because the Court of Appeal went off on a frolic of their own. And they decided that liquidated damages were payable until PTT accepted the work. The Supreme Court, which of course is I say the new name for the House of Lords, it's been in place for over 10 years now. The Supreme Court in 2021 looked down its nose at the Court of Appeal and said, absolutely, you are not correct here. In relation to liquidated damages, in a termination situation, liquidated damages only apply up to the termination date of a contract, and after that date, general damages apply. And that's referred to as the orthodox or the general position. So the Court of Appeal had been on, yeah, as I said before, a little frolic of their own, trying to mix things up on this. If I go back actually to 2020 again, some of you will be aware that NEC4 brought out new amendments to the NEC4 contract at the end of 2020. This was before the Supreme Court decision had came out. And one of the amendments to NEC4 in 2020 was a confirmation that liquidated damages only apply up to termination, and then general damages apply. Now, I have to say, I start to scratch my head here when I think, is this a good decision for employers or a good decision for contractors, or is it a bad decision for either party? And the answer really, it does turn on the facts. If you are working on an oil refinery, just because everybody is very aware of how fuel costs are going up at the moment, actually the liquidated damages are probably significantly lower than general damages. So in this case, you would want liquidated damages to continue to apply because they are far lower than general damages. However, if liquidated damages in the contract are on the high side and general damages would be lower, actually, this is a good decision. So it will turn on the facts. Another case came up in 2021 called Eco World and Dobler, and this again was all about liquidated damages. And again, we go back to JCT contracts, this time a JCT 2011 trade contract. Eco World were the employer and Dobler were the trade contractor. And this was all about facade and glazing works to 3 apartment blocks. Importantly, the contract didn't contain any sectional completion, which actually I think is a little bit unusual when you've got 3 separate blocks of apartments. There was a single rate of liquidated damages, £25,000 a week, capped at 7% of the final trade contract sum. The contract did allow partial possession. However, there was no clause confirming that there would be a reduction in liquidated damages if there was partial possession. 2 of the 3 blocks were taken over in June 2018, and practical completion happened in December 2018. What happened next was very unusual. The employer, EcoWorld, claimed that the liquidated damages was unenforceable, essentially because it wanted to claim higher general and uncapped damages. On what grounds did it think that the liquidated damage clause was unenforceable? Well, essentially because there was no reduction for partial possession. Dobler, obviously quite cute here, they wanted the liquidated damages to apply because it was £25,000 a week and the figure was capped. The court held in this case that the liquidated damages applied and Dobler as the contractor were very happy. The court pointed out that these liquidated damages had been negotiated by external lawyers, and the lack of a reduction for partial possession was irrelevant. The court also noted that general damages would be difficult to quantify, and there was no evidence at all provided that the liquidated damages were either unreasonable or disproportionate. So essentially, again, the court's saying here, actually, we're sticking with the liquidated damages. And on we go to the next case. Local case for me, so Transport for Greater Manchester and Kia. And I'm sure you will all let out a cheer when I confirm we are on an NEC dispute on this one. This was an NEC3 main contract, and it contained dispute resolution option W2. Now, W2 is the one that I would expect to see in place where the Construction Act applies. So far, nothing unusual at all. And the standard clause W2.4 in the NEC contract says if there's an adjudication and either party are unhappy with the adjudication, they can essentially issue a notice of dissatisfaction. However, the notice of dissatisfaction must be given within 4 weeks of the adjudicator's decision. Otherwise, the decision made by the adjudicator stands and is binding. So, what happened next? 25th of November 2019, the adjudicator's decision was issued. Both parties looked at this particular decision, and Transport for Greater Manchester were not very happy with it. So, Transport for Greater Manchester's solicitors issued a notice of dissatisfaction to Kia's solicitors. Kia looked at this and thought, is that a valid notice of dissatisfaction? And in particular, they looked at clause 13.2, which effectively says that in order to be valid, it must be sent to the last notified by the recipient for receiving communications. We have Kia saying this notice of dissatisfaction is invalid, and we have Transport for Greater Manchester saying that it's valid. Transport for Greater Manchester then issued Part 8 proceedings regarding the dispute, claiming that this dispute was still ongoing. They still had an issue, it hadn't been settled. Kia issued Part 11 proceedings challenging the jurisdiction of the court, claiming that the notice of dissatisfaction was invalid and therefore the dispute was finally settled and they shouldn't be there at all. The court reviewed both W2 and clause 13.2, and they looked at the situation before adjudication. And indeed, the works information is where the last address was set out, and that effectively said that communications had to be sent to each other using the project extranet, so some kind of document management system. However, during the adjudication, both parties provided their solicitors' contact details for communications in connection with the adjudication. I have to say that I do think this could have gone either way. The court recognised that W2.4 notice provisions are mandatory and strict compliance is necessary in order for the notice of dissatisfaction to be effective. But they also pointed out that clause 13.2 was also valid. The court decided that the notifications by each party confirming that their solicitors' addresses were to be used validated those addresses and actually gave 13.2 a tick. Therefore, the notice of dissatisfaction was valid, and Transport for Greater Manchester could therefore correctly say, no, this matter is still in dispute between the parties, and they had the right to actually take that dispute to court. I haven't seen any further correspondence to know whether this has actually been settled or whether we're going to see Transport for Greater Manchester versus Kia take two and see whether this whole adjudication is going to be revisited. So, importantly, here, takeaways would definitely be to understand that notice of dissatisfaction procedure. And actually, generally, I would also want you to have a good read of 13.2 and make sure that you are complying with the notice provisions. Again, earlier this week, I was lecturing on NEC contracts, and this particular issue came up. And it turned out on this particular job, they're using two separate document management systems. One document management system is actually referred to in the contract. The other one is being used for document transmittals, which of course would include drawing changes, and that isn't referred to in the NEC contract. So I said to the contractor I was working for, this needs to be sorted out and soon. You need to actually update clause 13.2. Another case, Toppen and Simply. It's lovely case names today. Who are the parties here? Well, we've actually got three parties. We have the contractor, Simply. We've got Toppen, who are the freehold owner of the care home. And then we also have Abbey, who were renting the care home. And essentially, this was about defects in the care home that had been built. The owner of the care home and Abbey essentially jointly went to adjudication against the contractor Simply about the level of defects on the project, and they wanted a payout. And sure enough, the adjudicator did what they'd hoped and decided that Simply had to pay Toppen 1.07 million and had to pay Abbey 908,000. So far, so good. What's the issue? Well, the issue was that they were actually using a collateral warranty as a construction contract in order to route this particular claim to Simply the contractor. And what the contractor turned round and said after the adjudication was, hang on a second, this collateral warranty is not a construction contract, it's not an agreement for construction operations, and therefore there was no statutory right to adjudication. The court specifically noted that the collateral warranty was executed after the works were completed and the remedial works were completed by another contractor. What did the court decide here? There was no statutory right to adjudication. So all of the pain and suffering that these parties had been through the adjudication process effectively was a waste of time because the collateral warranty was not an agreement for construction operations. That was a nice short one for a change. The next one. Oh, I want to hold my head in my hands as I go through this one. A very, very unusual set of circumstances. So we have here two parties. We have Mansion Place and we have Fox Industrial Services. This was an agreement in February 2020 concerning the refurbishment and extension of student accommodation. And we are back in the JCT realm here, JCT 16 contract with amendments. And there were delays on the job, with the construction company Fox saying all of these delays are due to COVID and late possession, and we're entitled to an extension of time. Whereas Mansion Place said, oh, no, it's not our fault. The delays are due to your lack of labour and resources. There was a phone call. On the 14th of October 2020, there was a phone call between Mansion Place and Fox Industrial Services. The parties agreed verbally that there would be no liquidated damages imposed and no loss and expense claimed. On the 22nd of October 2020, interim payment application 10 was issued by Fox. Mansion responded with a pay less notice on the 13th of November 2020, and that contained an intention to deduct liquidated damages. Fox were absolutely not happy with this. This goes against the phone call that we'd had. You have no right to deduct liquidated damages. We have agreed this particular matter. And the case goes to adjudication. On the 11th of January 2021, the adjudicator's decision was issued, confirming that the phone call was a binding agreement between the parties. Therefore, no liquidated damages and no loss and expense would be charged or claimed, and therefore the payless notice was invalid. Mansion Place were not happy, and off they stormed to court for a declaration. Either that there was no agreement or that they were entitled to revoke the verbal agreement. Fox Industrial Services, on the other hand, they wanted enforcement of the decision and a decision that the phone call was valid and binding, effectively on the rest of the project. The court reviewed the phone call. Now, it wasn't recorded. Okay, so of course they had to take witness evidence from the parties and look at the surrounding circumstances. They noted that both parties were in their cars on hands free, so no contemporaneous notes were taken of the phone call. It was also noted that the phone call was under 10 minutes and that it was cordial. And the court investigated the two parties. Manson's position was effectively that Fox was to proceed with the works pending amicable resolutions on all of the issues. Fox's version was that there was a binding agreement to abandon the claims on both sides and to proceed with the project. And essentially, what we have here is a typical situation of the scales of justice. Whose evidence does the court prefer? And in this particular case, it was decided that the court preferred the evidence from Fox. They looked at internal correspondence before and after, which evidenced the intentions of the parties and their understanding. And effectively, Fox's evidence ticked the boxes in terms of what they said was said, matched what was written about it. Manson's recollections, however, the court said were inaccurate, in particular the timing of an email. They claimed it was sent before the call, but it was actually sent after, and that bit undermined their believability. I did smile when I wrote the next line down. So the court essentially made a finding on the gist of a conversation on the balance of probabilities and held that this was a binding agreement to abandon the claims, that it was final and couldn't be revisited. That case, the thought of having to deal with who said what on a phone call, that's very difficult for the representatives of the two parties. And again, this case, in my view, could have easily have gone either way. That's an end to the cases that I wanted to go through, but we do have a coming soon part. And here we go again. I am yet again talking about the fact that there is a huge impetus in the industry to outlaw retention. October 2021, there was a bill introduced into Parliament seeking to outlaw retention. Just some facts and figures. There is an estimated £4.5 billion annually taken out of the economy through outstanding retentions. £1 million per working day is lost in retention due to insolvency. So every single day you guys are sat at your desk, £1 million is lost purely because of companies becoming insolvent. There was an estimate in 2018 that said there's around £10.5 billion held in retention. Lord Aberdare is the person who's sponsoring this private member's bill, and he's proposing two amendments to the Housing Grants Construction and Regeneration Act that we call the Construction Act, that brought in all of these rules and regulations on payment and adjudication. And you couldn't get anything simpler. Number one, all retentions are to be banned from the 1st of January 2025. Number two, all held retention is to be paid within 7 days of the 1st of January 2025. It is beautiful in its simplicity. Subcontractors, I think, are probably shouting hooray, although I can't hear them on the line at the moment. And main contractors are suddenly realizing that there could be a huge hole in their working capital if this goes through. Well, we've been here before, haven't we? So will it happen? Won't it happen? Who knows? Um, the courts were snarled up and Parliament was snarled up with Brexit. And then we got COVID. And now, of course, we've got all of the ramifications of what's going on in Russia and the Ukraine. I don't think retention is high enough up the government's priority list at the moment. So I am not holding my breath. We shall see. The second bit of excitement. Now, I appreciate I am talking today to CECA members, but I do know that every now and again you guys do dabble in JCT contracts. Could we see this year JCT 2022? Just the excitement. You can hear it in my voice. I am so excited about this coming out. I think it is going to come out, but I think we'll see the contracts issued in stages. So we might end up some of them even being issued into 2023. What things do I think are going to happen? I think there's going to be a bit of copying of NEC, and we are going to see the he that is all over all of the JCT contracts disappearing. I think we're also going to be embracing digital technology, in particular about signing and communications. To not have the ability to talk to each other through email expressly in a JCT is poor. I think the force majeure clause is going to be reviewed. I think they might introduce a definition. I think they are going to look at how issues such as Grenfell should be dealt with. And I think they may also put in extra clauses to do with MMC. So that's modern methods of construction or building off site, essentially. And we have already got one slight change, the dispute adjudication board. I have not seen that used yet. So on the coming soon, we've got the retention, we've got JCT 22. What other things have we got? We've got the Grenfell inquiry, which is continuing. There is an excellent podcast that's done on a daily basis that reviews what's gone on the inquiry. Um, we still have not sorted out what's happening with regards to the scheme for for funding the replacement of the cladding. But Michael Gove is moving forward with that. COVID cases. Every time I think that we're through it and we're there, the cases rise again. I think there will be more contract drafting about epidemics and pandemics. Certainly an issue that's it's affecting every single subby and main contractor at the moment are the issues of inflation and price increases. And that was the reason for putting in that very first case. More and more people will actually have either fixed price clauses. So it's a fixed price until the end of December this year, and then the price is revisited, or they will actually have a fluctuating contract as well. I don't think that item 4 is going away. We have the building safety bill also coming in, which could extend liability from 6 to 15 years. We continue to have the issue of Brexit as well. In particular, one of the issues that I'm aware of is that we are still using the European, what would I say, the European marking scheme. It used to be called the British Standard or kite marking. That's going to be amended to a UK standard, but they keep pushing the dates back. Other ones, vaccinations and sick pay, I think we will see cases in the courts. Will we ever see a new Sue Gray report? Don't know. Will the national insurance increases come into play? Again, that's something that's hotly debated in the House of Parliament. I think we will see more and more environment related legislation. I think that we'll see grants for electric charging points to homes, heat pump grants. I think will get much more press. I think well, certainly large companies have to do more climate change reporting, and of course, plastic packaging and tax as well. I'll go to the bottom one next. The red diesel issues, 1st of April 2022. CECA is working extraordinarily hard in terms of lobbying the government and MPs about this decision being put off, obviously because of the fact that diesel prices have increased significantly. The other two on the list. Okay, I admit these are not construction cases whatsoever. Lord above, the Wagatha Christie case. Of course, for those of you who don't know, this is all about Rebecca Vardy and Colleen Rooney, and whether Colleen Rooney actually libelled Rebecca Vardy in relation to an allegation that Rebecca Vardy was releasing stories into the media about Colleen Rooney or not. Can I say to all of you guys, follow this case? And not just for the celebrity gossip column side, but the evidence part of it is fascinating. The last bit that's come out on this, and we still haven't got the court case yet, the last part involved the personal assistant to Rebecca Vardy, who unfortunately dropped her phone in the North Sea only a few days before she had to hand it in as part of the discovery and disclosure process, and also a missing laptop. It is fascinating. The one I have crossed out, I am devastated about. Some of you might know this, the Colin copyright case. This is all about Colin the caterpillar, and it's could I say cousin? Probably not. Another case, I think, I can't remember whether it was Aldi or Lidl, who had come up with a very similar looking cake, and Marks and Spencers were claiming that there was breach of copyright against the other supermarket. Essentially, here the parties have settled their differences. So I am not going to have a case and a picture of Colin the caterpillar on slides going forward, for which I am devastated. So hopefully Gemma is back on the line. Gemma, I've managed to cut the question time down to 4 minutes. Deliberately? I don't know whether it's deliberately or not, but there has certainly been some action in the chat area. Um, so I know that Gemma is on her way back, and hopefully she's going to do her fancy question thing and actually bring up. Here we go. I knew she was there. Right. Okay, so a question from Paul. Were there some cases on whether a payment notice and a pay less notice are interchangeable, which found that the labelling didn't matter? Now, the Henier and Beck case is a while ago. Grove and Balfour's was an important case, but none of them particularly touched on the issue of labelling. And there are some cases about labelling, and I think 3 or 4 cases said that in relation to payment notice and pay less notices, you must make sure that they are what they say. And the phrase that the courts have used is that the notices must be correct in substance, form, and intent. And several cases use that terminology. So, can you dress something up as a payment notice and then change your mind at a later date and say, aha, sorry, I made a mistake. This is a pay less notice? No, you can't. The courts would be strict on that particular issue. Okay, Gemma, I think there's another one. Okay, right. Is there any way subcontractors could claim retentions held by clients against main contractors where the main contractor is now insolvent? Tony, you suspect not, but I can see that fingers are tightly crossed in this particular one. You would need one hell of a clever clause to be able to do that. So let's just think about the subcontract between the main contractor and the subcontractor. Okay, so that generally is a stand alone contract. There is a piece of legislation called the Contract Rights of Third Parties Act, but it's a one-way street, allowing an employer to be able to jump into the shoes of the main contractor and claim down the line. I think what you would need to have, and I am absolutely not using the right terminology, but similar, what you'd need is the equivalent of a parent company guarantee. But rather than it being you getting a parent company guarantee off the main contractor, what you would actually be looking for is the employer to sign a document that says if the main contractor becomes insolvent, then we will pay you the retention back. So I think it's possible, but I just don't think that that will ever happen in the way that we currently operate at all. Um, I think that if you ever see that in place, that would be a contract that you would want to get involved in. I suppose we're touching on this a little bit with the possibility of project bank accounts and the fact that um, in project bank accounts, subcontractors are paid far more quickly. I think what subcontractors need to do is start sending letters into their MPs